These are all on.
And then, of course, the PDA puts it on their website.
This is pretty good to pull this off.
So the press
Snap's gonna get that garage built. Gonna get the garage built and then what? It's gonna retire.
Welcome back, everyone. Great to see smiling faces, and I hope everyone had a great and wonderful summer. Let's start off with the Pledge of Allegiance. And Representative Avalani, could you lead us?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
So before we get started, I just wanted to take an opportunity. Representative Geising, do you want to introduce yourself real quick? We got a couple of new members on the team.
Thank you, Mr. Chair. Yes, I'm Representative Henry Geisen out of Goffstown, and thank you for having me on the committee.
Great, welcome. Welcome back, Representative Seaworth. Do you want to reintroduce yourself to the committee?
Just when I thought I was out, they pulled me back in. Brian Seaworth, I represent the town of Pembroke. I've been on labor a number of years, but this session I was moved to finance. And when a spot opened up, I agreed that I could probably handle 2 committees for the second half of this year. So I'm really happy to be back among all your friendly faces.
Oh, well, welcome back. Welcome
Thank
back.
you.
And Representative Butler.
Hi, Billy Butler. I represent Summersworth. Glad to be here. Thanks.
Great, thank you. And everyone else, welcome back. Representative Ryan.
Good morning.
Good
I'm
morning.
substituting this morning. I'm usually on RRD. I plan to be on time, but a tree fell on my road, so
Ooh, that's not good.
I borrowed my neighbor's car to get here.
Well, thank you for coming. I appreciate it. So the order of business today is to reconsider 2 retained bills from last term. The first one that I would like to open the session on is HB 128, establishing a committee to study unemployment insurance. Representative Granger, do you have a motion?
I move ITL.
Second.
And Representative Avalani, seconds. Is there any discussion? Seeing no discussion. Yeah, please.
I think that's my bill, if I'm not mistaken.
No. It's Granger's bill.
Oh, okay. Thank you.
You were adamantly opposed to this bill, by the way. So, but you can sign on as a co-sponsor and speak if you'd like.
I'm good.
Okay.
Just catching up.
All right, we got you. We got you covered. Seeing no further discussion, I'd like to close the session on HB 128. And pursuant to the,
Point of order, Mr. Chairman.
yeah,
Was that a unanimous vote to ITL?
no, we have to vote. I'm going into the executive mode to vote on it, correct? All right. Thank you, sir. I appreciate you watching my back. Okay, so what I'd like to go into executive session right now to consider HB 128 for a vote, and Representative Granger, do you have her motion? Well, we're now in executive session, so we're backing up.
I move ITL.
All right, Representative Avalani, second. Are there any further discussion? No further discussion, executive session. Mr. Clerk, would you call the roll?
Rep. Evelani.
Yes.
Rep. Seaworth.
Yes.
Representative Flanagan.
Yes.
Representative Prout. Representative Warden.
Yes.
Representative Drago.
Yes.
Representative Granger.
Aye.
Representative Hall. Clerk, yes. Representative Geisen.
Yes.
Representative Sullivan,
Yes.
Representative Cahill,
Yes.
Representative Ryan,
Yes.
Representative Susie,
Yes.
Representative McKenzie,
Yes.
Representative Schultz,
Yes.
Representative Leclerc,
Yes.
Representative Staub,
Yes.
Representative Butler.
Yes.
Okay,
And me.
sorry, Representative Creighton.
Yes.
18-0.
Okay, the motion passes 18-0. The executive session on HB 128 is now closed. Yeah, you're gonna do the blurb on that? Thank you. Okay, that was simple. We're halfway done. The next bill that we retained is HB 303 relative to requiring the Department of Labor to review and adopt workers' occupational safety requirements that are similar to OSHA standards. We had a long discussion on this, and after that discussion, we decided to retain it. And Representative Sullivan has been working hard this summer to essentially narrow the bill down in scope so that it's less impactful on the towns and we don't create a huge burden on the towns. And yet we try to take care of workers at their workplace at the state level. Remember, the state does not require OSHA standards. The Department of Labor runs that. And so we're taking a look at that aspect of the OSHA standards. Representative Sullivan, do you want to reintroduce the bill and then talk about your work this summer?
Geez, you already did everything, I think. Yes, HB 303 is exactly what the chairman said it is, or I should say was. The bill as presented earlier in the session was intended to introduce new rules for the Department of Labor that would mirror or closely resemble the OSHA standards that the private sector lives under. It became clear to me coming up on the vote on this that this was not going to fly, and I'm not interested in jousting at windmills. I would like to accomplish something. So basically, I made the motion to retain the bill. That motion was adopted, and we've, frankly, the chairman and I have worked together to try to come up with something that would narrow it, as the chairman said, and would hopefully pass muster with the committee. So, in front of you, if you haven't stumbled across it already, is an amendment. It is 2025 3002H, and it substantially alters the original bill. As I said, the original bill was going to adopt standards that would be similar to the entire OSHA book, so to speak. This narrows it substantially to only subsection S. Subsection S deals with electrical safety. As I've testified repeatedly over the years I've been working on this, one of the ironies of the Labor Department's standards for public sector is that there are no standards for electricity. So effectively, I thought, and I think the chairman agreed, that if we were going to do something, perhaps that would be a good place to start. And so essentially, this amendment takes one small section of the standards. I shouldn't say small; it's a substantial section, but only one section of the standards to adopt, and it still has the language that it would be, I'm looking for certain, hold on. It would be a level of protection that is at least as effective as the protection set forth in the OSHA standards. So it has to be at least as effective, but not identical. So as I've testified in the past, this was an idea of the Department of Labor. They said we can write the rules in English so everybody can understand it, employers can understand it, employees can understand it. We can also simplify it somewhat. We can also introduce a bit of New Hampshire common sense to the process, so that if there's some aspect of the OSHA standards that would require us to do something that is unnecessary, and we can do it just as well with another method, the department can do that. So essentially, we've got a simplified process. We've got written in English, and we've got it with New Hampshire common sense introduced. And this amendment only deals with the electrical standards. With that, I will close and take any questions that people have.
Are there any questions? Representative Flanagan.
Thank you, Mr. Chairman. And it's good to see you, Representative Sullivan.
Likewise.
So if I understand, two parts to my question. If I understand correctly, what you're saying is we're going to take a smaller bite at the apple instead of trying to get the whole apple by doing it this way.
Precisely.
And the other question, though, I have is the term as effective. Who's going to decide its effectiveness as a relationship to OSHA standards and our standards? Are we going to default to our standards regardless of what it may say OSHA-wise?
The department will write the rules, and the rules will be subject to JELCAR hearings. And if the department, I have a great deal of confidence that the department will write rules that will be as effective, but will be perhaps easier to implement. If they miss the mark, there's a hearing before JELCAR, and that would offer an opportunity for someone to object to the rules as they're written. So the department makes a determination that those rules will go before the JELCAR committee.
Yeah, and it might not necessarily be Representative Sullivan, but is there someone in the audience that is from the electrical folks or any?
We have people from the Department of Labor.
I noticed that, but you're not representing electrical, right? Okay. All right, thank you.
Okay, thank you. Are there any other questions? Representative Avalani.
Thank you, Mr. Chairman. We've worked on this for a number of years, and I'm glad to see that we are moving forward with a smaller section. However, why only electrical? Why not something else too that's smaller that would allow them to continue to work, and then we can monitor them in the next session?
We did ask the department for recommendations as to what sections might be pursued. The department indicated that they felt that was a policy decision best left to legislators. So I went through the whole 1910 OSHA standard and reviewed it all. I looked at the electrical, and as I've said, that's a glaring omission in our standards. It's substantial. So I thought that I looked at possibly adding a couple others, but my thought, and I discussed it with the chairman, so let's look at substantial glaring omission and deal with that. We could have added more. We didn't. Could have. But, and frankly, in discussions leading up to today, we've discussed the possibility of, going forward in future sessions, taking additional bites. And so I would anticipate that may very well happen. And I also would say that the department has been working on some other sections as well.
Thank you, Mr. Chairman.
Are there any further questions? Representative Granger, sir.
Thank you, Mr. Chair. So the largest and most important component is safety is simply having good sense, like good common sense. And among blue collar workers, there's sort of a hierarchy, an unofficial hierarchy of which ones require the most intelligence in order to do. And electricians are generally among the smartest blue collar workers. So why should we interfere with the way they do things when they're the ones that are most likely to know what they're doing?
I don't think this is exclusively dealing with electricians. It's dealing with safety, dealing with electricity. So in some instances, it might be, inspecting the workplace to make sure that there are no electrical hazards. And so it may be someone other than an electrician who makes an error. Another reason why I thought that this would be an important place to start is that electricity is inherently dangerous. I consider myself sort of a handyman. I will even do some electrical work. I won't touch the breaker box. That's where I draw the line. Because it scares me, and I don't want to make an error that's going to hurt me or my family. So I think this is a good place to start, and it's not just electricians; it's any electrical hazard, no matter who created it.
For a follow-up.
Thank you, Mr. Chair. So I recently did put in a 240-volt line at 50 amps in my house.
Good for you.
It was a lot of fun. But doesn't this sort of impede on code? Wouldn't this fall under code enforcement rather than OSHA or labor?
Good question. The code is one thing, safety is another, and they may overlap. Obviously, if you do something that's not according to code, it may also be unsafe. But basically, this is looking at whether or not the electrical systems are safe, not necessarily to code.
Representative Drago.
Thank you, Mr. Chair. I'm actually not sure if this is a question for you or if it's for you. It looks like this email or the data we have actually went to you. I'm just trying to understand this. So basically, we were asked the injuries for electrical and over the past 10 years. And it looks like they took into account per 1,000 employees. Am I reading this right?
That's correct.
Okay, so then follow up. So I guess what I'm looking at is in every single year, the public sector per 1,000 employees was drastically lower than the private sector. Am I reading this right? For injuries?
And Mr. Allen, you want to describe your chart? Can you do that for the committee, please? No, Representative Solomon, you can just stay right there. He's just going to describe the chart.
Mr. Chair, would you please let me know what you would like for me to describe to
So
the
the,
committee?
the question was, on the chart that you put together, what did the data show?
To address Representative Drago's question, it looks like there are 3 years based on the data provided by the New Hampshire Department of Labor and cross-referenced with the Employment Security Office's employment information, that there was a higher rate per 1,000 employees for the public sector. Those years are 2021, 2022, and 2023, though they are very close in 2023 for the rate per 1,000 employees. I know it's a little difficult on the black and white copies to distinguish, and that's why there's both the chart and the table.
Okay, thank you for explaining that. I appreciate that. Does that answer your question, Representative Drago?
Yeah, thank you.
Okay, thank you. Are there any other questions for Representative Sullivan? Representative Cahill, sir.
Thank you, Mr. Chair, and thank you, Representative, for taking my question. I wanted to sort of refer to my friend, Mr. Drago, that there, as we know, the private sector is by far the largest employer, and there would be certainly more incidents. But my question is whether or not there's any information about how serious these injuries were. Were there long-term repercussions for the employee? Did it cost a lot of money out of the workers' comp to attend to these injuries? And if I just one more, in my home, next to the electric panel, there is a sump pump, which is not a good place for it. So there you have this place with water next to the electric panel. So I was instructed to put a board over it. And I did a little bit better by putting concrete blocks. So there are hazards that happen sort of after the fact, after the electrician has been paid and gone.
So Representative, is there a question that you're asking, or are you making a statement?
I did make a statement there, and I beg your tolerance.
This time.
And there were questions before.
Thank you. All right,
I,
1 second.
I
Representative
don't,
Sullivan.
I don't think we have data here that expresses the seriousness of the injuries, just the number of injuries. I would say that the columns show the total number of injuries, and so obviously the public sector or private sector is much higher columns because there's a whole lot more of them. But the lines with the dots on it represent the per thousand, so that's where that data comes in.
All right. Representative McKenzie.
Thank you. If the original legislation, which ended up creating the rules to govern public sector, the bill was passed in the early 80s, and I helped write the legislation at the time. If you look back, and I have the information I can always provide for the committee, but if you look back on the original intent of the legislation that produced these rules, it was to bring the public sector up to the private
Okay,
sector.
are you asking the representative a question, or are you making a statement
Well,
to
I
the
guess
committee?
I'm doing a little bit of both.
It sounds like it. Is like
So
something
should I
in the
suspend?
water this summer where we're gonna do that? So please ask the,
Background, Mr. Chairman, right?
As, if you'd like me to shut up, I'm happy to do that.
no, I would like to give you the floor to ask a question as appropriate. And how you frame that in your vast years of experience, I'm sure you can,
We
Figure
will
out
have
how
an
to get to
executive
it.
session, right?
we're going to executive
All
session.
right, then I'll hold that.
Thank you.
Thank you,
And
Mr.
thank you. Are there any further questions? Seeing no further questions, thank you, Representative, for your work, and thank you for your testimony. Okay, what I'd like to do is there's no other testimony. We're in executive session. Representative Flanagan. Ms. Albert, do you have any comments on the proposed amendment?
Button. I always have to remember to push the button. Good morning, I'm Danielle Albert. I'm the Deputy Commissioner of the Department of Labor. I'm here today with John Garrigan, the Department's General Counsel. We appreciate the opportunity to be here. The department has, as of this morning, had the opportunity to review the amendment. We do believe we understand its stated purpose. Exactly as Representative Sullivan had explained, it is taking the original bill and narrowing it to placing an obligation on the department or the onus on the department to promulgate rules that are at least as effective as OSHA 1910 subpart S, which is relative to electrical safety. We do believe that we can implement that as requested. I guess a couple of things that I would note, just relative to the rulemaking process itself, it can be somewhat of a lengthy process at times. It takes time to draft the rule itself. That can be anywhere from 6 months to a little bit longer, dependent upon the complexity of the rule. And then it's about a 6 months, sometimes a little bit longer turnaround time after filing with GELCAR. So it can take up to a year, maybe a little bit more for rules to, be finally approved and put into effect. So I do think that time frame is an important one just to be cognizant about. We understand from this proposed language, as I read it or as I understand it, that the department is required to have these standards implemented at least 1 year post-effective date. And then, as I understand, there's some discretion given to the department, or authority given to the department to determining the timing and priority of that implementation. So we do believe that we can regulate that. Certainly, some time and thought would need to go into looking at subpart S and then crafting language to go into the rule. That would take some time, but again, we believe that's an undertaking that we would be able to carry forward as intended. As noted earlier in this meeting, the department has been working on certain sections of the administrative regulations. It's the Lab 1400s. I had forwarded a copy of the changes that the department has proposed to GELCAR to Mr. Allen, who I believe was kind enough to forward to all of you. I appreciate his assistance with that. The department had made the committee aware last session that we were looking at 5 specific sections to really undertake some changes to more clearly define requirements for employers relative to safety. Those 5 sections are confined spaces, exits, flammables and combustibles, ladders, and wires, ropes, and rigging equipment. So we have made amendments, again, to those sections of rule, really clarifying and detailing the employer's obligation to providing workplace safety to their employees. In that context, those rules have been put forward to GELCAR and were just last week conditionally approved. So they're underway. They're not yet effective, so they haven't been finally approved, but the conditional approval is in place. It is our intent to continue working on the 1400 rules, examining the sections and assuring that they're not static, that they're being reviewed for necessary changes. And again, certainly if there is a clear mandate in the statute that electrical is to be a part of that, we believe we can craft rules in that regard. And I'm happy to answer any questions if there are any.
Okay, thank you for your testimony and clarification. Representative Labrie.
Thank you, Mr. Chair. Good to see you.
Good to see you as well.
Quick question for you here. I don't see a fiscal note on this. And is there any cost, new hires, or draw on the Labor Department to handle this?
That's an excellent question. I believe on the original bill, we did do a fiscal note, to my recollection. For the amendment, we've not yet received a fiscal note request. It's very difficult to quantify. So certainly the scope of this proposed language is not as vast as the original language. The original language did make, as I recall, authorization for the department to hire up to 7 additional staff persons, some being safety investigators and some clerical support staff. At this juncture, our assessment, I mean, we would need to perhaps look at that, but I don't know that we would need additional staffing, but that would really depend on what that rule looks like. That would be in relation to department cost. As far as quantifying cost to the public employers, the state, the towns, the municipalities, and other public entities that they would be subject to, very difficult to quantify. It's dependent upon what types of changes each individual employer would need to make in order to come to compliance with the newly stated requirements, and that's just a very difficult number to quantify.
For a follow-up, sir.
Thank you for that answer. On January 22nd, the governor implemented a no hiring freeze. To my knowledge, that hasn't been lifted. And as you referenced in the first fiscal note, that was up to 7 hires, and it was over a course of 3 years, 1.8 million.
Right.
So I just want to make sure that the taxpayer is not impacted by
Sure.
this. So I know we don't have that fiscal note. Do you feel comfortable that there wouldn't be a big lift?
Are you asking from the department's
From the
end and from a
department's perspective,
staffing
yeah.
end?
Yeah.
At this juncture, and we have had some communications with Representative Sullivan and Representative Creighton, were both wonderful in reaching out to let us know this was the direction it was going into. At this juncture, it doesn't appear so. Where I think I'm a little bit uncomfortable saying absolutely not, and I don't want to give a definitive if it's not appropriate to give a definitive and come back later and say, oops, I was wrong. I think we would have to get into the meat of crafting that rule. Having taken a look at subpart S, it doesn't appear to be so. We have 3 safety inspectors currently and a support staff team that are part of our inspection division that are already carrying out the mandates that are set forth in RSA 277 and the attendant 1400 rules. Um, Adding the additional section of rule doesn't appear to be so much, doesn't appear on blush to be quite so much. Now, once it's in force and effect, what types of compliance issues come out of that, what kind of lift that would look like, I'm not really certain how we would be able to predict. Certainly, I think it's reasonable to expect once the requirements are out and public employers have been appropriately educated that they're going to do their best to comply. And certainly if they're complying, there's less sort of regulatory enforcement that has to come along with it. So at this juncture, it doesn't appear to be so. I think it's a little difficult not having the rule crafted to say.
Thank you.
Welcome.
Representative Flanagan and then Representative McKenzie.
Thank you, Mr. Chair. I'm stuck on this two words, as effective.
Mhm.
Maybe the counselor can provide some, you're an attorney too, aren't you?
It's the better attorney.
He's a, oh, stop. Just hypothetically say that someone has an accident in their workplace. And the employer says, well, I'm in compliance of this new law. And let's just say it's not as strong as the OSHA policy might be, because OSHA doesn't deal with New Hampshire, right?
Mhm.
The concept of New Hampshire, live free or die. Hopefully the person didn't die. What happens when there's a conflict? In other words, could someone come back to us as a state that says, well, the law says it's got to be as effective, and you chose to do something opposite of what OSHA is?
Mm-hmm.
Do we have to be explaining why we feel it's more effective to do it one way versus the OSHA way? And is it, by doing that, does it open us up for potential litigation over and above what the employer might be experiencing in a situation where there might be electrocution or things like that?
It's an excellent question. I mean, as I understand the proposed language, it is on the department. It's within the department's purview to assess subpart S and then craft language that we've determined is at least as effective. So certainly if those rules then go into effect, something occurs, and there's a question as to whether or not, one, certainly through the GELCAR process, I would hazard that that's something that the GELCAR committee would be looking at. There's a statutory mandate to make it at least as effective. Do we believe that the rule that the department has crafted has met that standard? The public is able to appear at those hearings and weigh in as to whether or not they think what their thoughts are, very much like a legislative process. I mean, there are ways for the public to petition the department about rulemaking, so that if something were to come up and there becomes a thought that it's not as effective as the federal requirement, there's ways to petition the department to either undertake rulemaking or relook at a rule and potentially put forward changes. Whether or not it would require a statutory amendment, I'm not sure. And I'll look at our counsel in case there's anything I've not considered in that regard. I suppose it potentially could.
You never, follow up, Mr. Chair?
Yes, please.
A continuation of the discussion in that people can sue for any reason.
Mhm.
And if the employer says, well, I just met whatever the state
Right.
requirement was, so that takes them from, a legal perspective, they followed the rules. So one's going to come back and say, well, maybe the rule wasn't right.
Mhm.
And that's why I'm been electrocuted and lost lives or whatever. Does it then fall on our shoulders? Because someone could come back and say, well, OSHA said this and you said that. Is it as effective? I don't feel comfortable with it. That's all.
Okay. I mean, is the question in terms of whether or not the state itself could be sued
Probably.
in that context? I mean, suing the state is a endeavor. I'm not sure that they could. I mean, certainly when we're talking about any type of workplace injury or accident, and certainly anything electrical related, public or private, is more likely than not, one, we don't want it to happen, certainly. But if it does, it's more likely than not going to fall within the realm of the workers' compensation system because it's occupationally related. So when we look at the workers' compensation statute, there are mechanisms in place whereby you are unable to pursue against your employer. Now, whether or not you can pursue the state for failing in some sort of obligation, I suppose folks could bring any type of suit that they wanted to, but I don't know whether or not it would be meritorious. Or I don't know how far it would
I just
get.
have one more follow-up. Is that
Okay,
if-
one more
I will.
quick follow-up, and then we'll go to Representative McKenzie.
And he's going to fall asleep if I don't hurry up. If we amended this amendment that basically says that the state's standards would supersede OSHA standards, then my concern would be out the window because, and no one could come back and say, well, you should have followed the OSHA standards. Well, the law says that our standards supersede OSHA.
I don't know that the state standards could supersede OSHA standards in this context because OSHA standards technically don't apply to employers in this context. I understand this language more so to be mandating the Department of Labor to look at the OSHA regulations and in essence make assessments about what those safety requirements are and come up with safety requirements for
Of
the
their
state
own.
that are at least as effective.
Okay.
Okay, good questions. Thank you.
Could I just
Yes,
tack on one
please.
answer to the question
Mr.
about
Kerrigan.
state liability? I mean, I'm not going to speak for the Attorney General's office as they would defend the state in any such case, but I will say sovereign immunity is a very real thing and would likely make any litigation against the state for something like the efficacy of a particular law or rule very difficult.
Thank you for that. Representative McKenzie, sir.
Thank you. Is it the practice of the state to promulgate rules following the passage of laws?
Certainly where we're mandated to do so, yes.
Further question?
Yes, sir, for a follow-up.
Thank you. In the case of the electrical standard, as I understand it, applies whether you are public or private. So you have a code, electrical code, that would apply to both public and private sector. That's a state standard, correct?
As it relates to the codes, I do think that there is, and I think it was Representative Sullivan put it very well earlier, there are codes and then there are the safety statutes and there's overlap between the two, but they are distinct from one another. So I'm not very well versed at this juncture, perhaps I will be in about a year, in the electrical codes. So I'm a little bit hesitant to say yes or no on that since it's not exactly my wheelhouse. That would make sense to me. Now, as it relates to the safety standards would be applicable to public employees. And as I understand Subpart S, who are working, with or around electrical. So an employer may still need to abide by certain codes. They also need to abide by then the workplace safety standards that are at issue. And the overlap of codes is not something that is new to the realm of public safety. There are existing building codes and other types of codes that talk about exit requirements and whatnot, that there's already overlap where the department is mindful or the rules make reference to those codes.
One final question.
Yes, sir.
So would it follow that the OSHA standard, the law that implements for private sector, has a series of rules, correct?
Correct.
So if you flip over to, if you flip over to the public sector, you have the same code that governs both groups. But the standard that is in effect for the code and the OSHA standard does not apply to public sector. So are we trying to fill this void between the standard for OSHA and the rules and the standard for the electrical standard and that for public sector workers?
I understand the amendment to be addressing what has been described as a lack of definition or a gap in specific regulation of electrical safety in public workplaces. OSHA does mandate that through Subpart S for the private sector. Again, I'm not that well versed in codes, but codes tend to apply to buildings or areas. I don't know if they're contingent upon private or public. So I understand this amendment to be a way or a mechanism of giving the Department of Labor more specific authority to promulgate safety regulations, again, that are at least as effective as the OSHA regulations that apply to electrical safety for the private sector so that they apply to the public sector.
Thank you.
Okay, good questions. Thank you. Representative Cahill,
Okay, Mr.
for a
Chair.
question.
Yes, thank you. And thank you, Deputy. Could you tell me anything about the type of injuries, the severity, or fatalities that have happened in both the public and private sector related to electrical issues?
I have the numbers that were previously provided to the commission showing the comparison of number of electrical related injuries reported to the department between 2015 and 2025, comparing private to public. Drilling down into the severity of an injury can be somewhat of a challenge. There are multiple factors that go into determining whether or not, what is the severity of a workplace injury, and not all of that information is required to be filed with the Department of Labor. So I don't have that type of data today, and it could be somewhat difficult for the department to drill into. We certainly know the number that were reported, but how many resulted in lost time from work or the severity of medical is a very difficult one to quantify, in large part because when an insurance carrier is making payment of medical benefits, they're not required to notify the department of such. There's no dispute, so they're simply paying. We don't have record that the bills are paid. They're only mandated to notify the department when they're not paying a bill. So if there's extensive treatment for a compensable injury and there's absolutely no dispute that it's the insurance carrier's liability, we would have very little, if any, record at all about that medical treatment. So it's a bit difficult for us to quantify.
Thank you.
You're welcome.
Representative Staub.
Thank you, Mr. Chair. From what I understand, OSHA standards are evaluated and changed on an ongoing basis. Representative McKenzie referred to the fact that the original rules were written in the 1980s. Are you aware of any other continuing updates to these rules that have happened since in the last 40 years?
To clarify, you mean to the OSHA regulations?
No, to the state standards.
To the state standards.
Yeah.
The state
Thank you.
standards, to my recollection, they were last. So all administrative rules for the state, with the exception of certain types of rules like your hearings procedure rules, are going to automatically expire after a 10-year period. My recollection, and I'm doing this from memory, so please forgive me, I will correct myself if I'm wrong. I believe back in 2017 or 18, after 277-15B went into effect, the department did make some amendments to the 1400 safety rules to address the fatality and serious injury reported, those new requirements. So the undertaking that we are in right now, the rules are set to expire, but about a year ago, we started, really working at taking a look at what needed to be perhaps clarified or more fully fleshed out so that employers were clear on what their obligations were in relation to providing workplace safety for their employees. You're welcome.
Representative Granger, sir.
Thank you, Mr. Chair. Quick question. Is 1910 subpart S, is it partially based on National Electrical Code?
I'm not sure. I would have to look at it in great detail. I'm happy to take a closer look at it, perhaps with Attorney Garrigan, and follow up with you if that's okay.
Okay, thank you.
Sure.
Representative Warden, and then Representative Avalani.
All right, see if I can put this in the right words for you. In order for you to determine whether an OSHA rule standard is effective, would not you have to look at the incidents of accidents before and after that rule was put into place?
I want to make sure I understood the question correctly. Is the question that in order for the department to determine whether or not they've promulgated a rule that's at least as effective as the OSHA standard, would we need to look at certain types of data to determine
No,
that?
let me say it
Okay.
differently. In order to see if something is even effective,
Yep.
if you're going to continue to use those words as
Mhm.
effective level of protection,
Mhm.
you'd have to know whether that new rule actually helped prevent an accident, whether it saved somebody. So you'd have to look at before and after that rule was put into place to know if it's effective, if we're going to use the language, the English words, as effective as.
I think that is a way of measuring that.
Agreed. So follow up. So are you going to endeavor to research that? Every single rule in subpart S, are you going to look to see when that was implemented and whether specific incidents or the levels, numbers of accidents went down? That's the only way to know if it's actually effective.
That's a very fair question. I think it is an approach that the department could take. I can't say that we, at this stage, have fully planned how to go about assessing that, but I certainly think that is a means and a mechanism for the department to consider in going forward and determining that.
Follow up. Would it be easier if instead of as effective as, if we just said as onerous as, or as authoritative as, or authoritarian as, or as a restrictive as? Would that be easier for you?
It's a good question. Certainly, as I'm not sure that I would know what as onerous or as restrictive as means. So I don't know that it would be. I really don't know that any of those any of that alternative language, if that would alter the exercise or the undertaking that the department would have to go through in order to make the determination about what is at least as effective as the OSHA standard.
Thank you.
Okay, great, thank you. Representative Avalani.
Thank you, Mr. Chairman. Thank you, Deputy Commissioner and Attorney Garrigan. Could you explain to the committee, because I don't think they were part of the original discussion a few terms back, of what happens when the state does not have rules or safety things, the general duties clause, and then what do you do when you declare that? What do you look at behind that?
Yeah, so the general duties clause really stems more so from, it works in conjunction with 277 and in part stems from the workers' compensation statute. And it sets a general mandate that all employers, both public and private, have to provide safe workplaces for their employees. In the past, in instances when the department has not had a particularly specific mandate such that the general duty to provide a safe work environment has been identified because there is an unsafe condition, the department does go to that clause and has in the past looked at the OSHA standards kind of as a framework for what that sort of standard should be. That's how it's been utilized in the past. The department has, in addition to the general duties clause, does also look at these areas under the safeguards and modification provisions that are set forth in 277, I think at sections 11 and 13, which give the department or through the commissioner authority to mandate modifications or safeguards when there's not a specific requirement to do, let's say, it's electrical or something that's very specific. Now, again, that's very broad. There's not a specific standard. In general, OSHA can be a standard that we tend to look at.
Thank you. Thank you, Mr. Chairman.
Representative Cahill.
Thank you, Mr. Chair, and thanks to Mr. Avalani for bringing up an excellent point. May I ask the deputy, what happens within the public sector now if there's an electrical injury and there was no standard? Is there litigation against the community for failing to provide a safe environment in this regard?
I don't know that the department would have information as to whether or not there's litigation by the community against a particular public employer. From a department standpoint, if a safety investigation had been instigated or initiated and a safety inspector were out there, there could be recommendations or the modifications or safeguard provisions or perhaps general duties clause may be cited to have that public employer implement some kind of either safeguard or modification to protect its employees from the identified electrical hazard.
Thank you.
Representative Drago, sir.
Thank you, Mr. Chair. I'm looking at the data still, and it looks like it's all derived off workers' compensation claims, basically, or at least the reports of injury.
Correct.
Follow up. So I guess.
Yes, for a follow-up.
Yeah, there might be a couple, sorry. My question is, I think last spring during this hearing or whenever we had it, somebody had alluded to the fact that it's quite possible that the public sector reporting of those injuries is more thorough, more superior than maybe the private sector, who they may tell their boss, but he may forget just because he's busy, or maybe he just pays for the walk-in clinic care. Is that something that you would agree with? I don't know if it was you that told us that, or if that's something you've seen.
I think it is, thank you for the question. I don't recall if it was me, it may have been. I think it is fair from the department's regulatory standpoint, certainly as far as late reporting or failure to report, which is something that can come to our workers' compensation division for, outreach and potential enforcement. Sometimes injured workers do contact the department to say, hey, I reported an injury, an employer's not been in touch with me, or I haven't heard from an insurance carrier. Can you help me? And in looking at our files, we don't see that an injury has been reported to the department. So we have certain regulatory actions that we take to resolve that compliance issue. Certainly, I'm comfortable saying that the bulk of either late reporting, which happens more than one would think, but late reports that come in, and outreach for lack of reporting tends to be in the private sector. By the same token, the private sector is a much larger employment sector than the public sector. So I don't know that I can say definitively the private sector is absolutely worse at it than the public sector. They're bigger, they're more employers. But if we're talking about, the department's regulatory interactions in terms of the requirements to file FROIs, our regulatory interactions are more often than not with the private sector versus the public.
Yes, sir.
So then looking at the data, looks like 7 out of 10 years, it was already the private sector that had more injuries than the public sector. But going by what we know, that I would say it's probably a 99% chance that the private sector does not report quite as much as the public sector does. So in theory, would you agree that these numbers could be a lot higher for the private sector for injuries, and therefore they're already covered under OSHA? So they already have the OSHA standards, and we're also seeing potentially even higher numbers than what's on this graph.
It's difficult to say. The department only knows what's reported to it. And we know what our regulatory interactions are. So I think it's a very difficult question, for us to answer. I don't know. We don't know definitively whether or not there are private employers who are not reporting. It's a very hard one, I think, for us to answer.
Is that all? You good? Okay. Anyone else? Back over to the left side.
Thank you. Based on your experience, and I see the inspector is here as well in the room, safety inspector, I believe, you introduced her.
With us today also is the Director of Inspections, Ms. Cottrell.
So let me just ask you a general question. We've heard presentations from the workers' compensation people about the declining expense of workers' compensation. Can you provide us an opinion relative to the impact that good safety standards have on the overall workers' compensation rate and on the overall injury rate in places of employment?
I don't know that I'm qualified to give that type of opinion. I am comfortable saying that it's my understanding that some of the additions to the workers' compensation statute, when 281A was recodified from 281 into 281A, specifically in relation to those 281A 64 provisions about the JLMCs and the safety summary forms, and where that general duty to provide workplace safety came from. The intent of that was to assure that employers were providing a safe workplace, with the hope of some forms of cost containments or reducing claims costs. As to an opinion of whether or not that's effective, I don't know that that's really within the department's purview to give.
Representative Granger, sir.
Thank you, Mr. Chair. So I'm doing some research on the state electrical codes, and it seems to me that a lot of the OSHA rules are derived from previous versions of the National Electrical Code, which we've already adopted in the state of New Hampshire. And when I went to the RSA that speaks about this, it's being actively changed depending on the year. So the permitting and the National Electrical Code that the state follows changes in 2026, and it appears to change in other years after that. So my question to you is, if we change this for labor, are we duplicating effort that should be handled by code enforcement? And will we have two different sets of standards in RSA?
It's a very good question. Not knowing specifically which RSA, or having read maybe in detail the RSA that you're currently looking at, I will come back to the statutes that tend to set the code enforcement requirements, whether it's electrical or building or whatnot, are are somewhat different, although there is interplay with them from the workplace safety rules. So is it duplicating efforts? I don't understand that to be the intent. I'm not sure I'm in a position to say at the moment, absolutely, it will not be duplicating some efforts. I do see the potential for interplay between the two. So if in order to promulgate rules that are at least as effective as subpart S under the OSHA requirements, some sort of eye needs to be turned towards what are the current electrical safety codes and how does that incorporate into crafting such a rule. That's something the department would need to look at in undertaking this exercise.
Thank you.
Welcome.
And Representative Avalani.
Thank you, Mr. Chairman. Does the Department of Labor enforce electrical code?
The Department of Labor does not enforce electrical code.
So if all,
Please.
so dealing with Part S deals with the safety aspect of personnel. So you could be, all right, you need to use a fiberglass ladder instead of a aluminum ladder. You need a 6-inch cuff on your rubber gloves instead of a 4-inch cuff on your rubber gloves. I mean, it'll be things like that that the department has jurisdiction over and make sure that employees are required, public employees are required to have those things available to their employees so they can have the adequate safety equipment to complete the job that their boss gave them.
I think that's a fair assessment.
Thank you.
Okay, seeing no further questions, I really appreciate your
course.
candid testimony,
Our
both of
pleasure.
you. Thank you again,
Thank you very much.
as always. Okay, what I'd like to do is take a 10-minute recess. I'd like to have a caucus in this room with my side. And so we can, let's make it 15 minutes and come back at 11:15. Can we do that? Thank you. call the executive session on HB 303 to order. And Representative Sullivan, do you have a motion on the amendment?
I think the proper order is to make a motion on the bill itself, and then the amendment comes after.
Okay, fair enough. Do you,
So initially, I would make a motion of ought to pass, and then I would go on to move amendment 2025-3002H. And for all the reasons I stated earlier, that's what I think we,
Mr. Chairman?
yes,
We need a second on that motion.
I'll do it. Second.
Thank you.
But we're not approving the first one, we're replacing the first bill with this one. So.
we're amending the original bill.
Correct. So your statement just said that, I'm sorry. Your reference was that we were going to approve the bill and then replace it with this amendment.
We are going, the initial motion is ought to pass. The motion will become ought to pass as amended.
but we have to approve the amendment
Correct.
first,
Correct.
right?
So I'm-
So
so
the
I'm-
first method, the first motion is on the amendment.
I'm moving the amendment.
Okay,
You're moving the bill forward with amended. It needs to be a positive motion in order to accept the
Correct.
amendment.
That's correct.
Question, Mr. Chair.
yes.
So if this amendment were to pass, right, would we then have a second vote on the ought to pass motion, or are we merely adopting the amendment?
There would be a second vote on ought to pass as amended.
So follow
Okay,
up.
wait a minute. Say that again, Brian, because you said the same thing twice.
We pass the amendment, then the motion goes from ought to pass as amended.
That's exactly right. Okay. All right, so we have a motion, we have and we have a second on the amendment alone.
Yes.
Any discussion? Representative Granger?
Just a question of the chair. So the motion is to adopt the amendment.
That's correct.
Thank you, Mr. Chair.
Yep. Seeing no discussion, Mr. Clerk, please call the roll. I didn't see any discussion. Go ahead, we're good. Go ahead.
Good. Here comes the roll. Okay, Representative Avalani,
Yes.
Representative Seaworth,
Yes.
Representative Flanagan,
Yes.
Representative Prout, Representative Warden,
Yes.
Representative Drago,
Yes.
Representative Granger,
Aye.
Representative Hall, Representative Labrie Clerk, yes. Representative Giason,
Yes.
Representative Sullivan,
Yes.
Representative Cahill,
Yes.
Representative Ryan,
Yes,
Representative Susie,
Yes.
Representative McKenzie, Representative Schultz,
Yes.
Representative Leclerc,
Yes.
Representative Staub,
Yes.
Representative Butler.
Yes.
Okay, 18-0,
Representative Creighton, yes.
sorry.
Okay, so we have the amendment approved. Now, do we have a motion of ought to pass with amendment on HB 303? Do we have a second? Okay, we have a motion and a second on to pass as amended. Are there any, Susie?
Thank you.
Are there any comments? Representative Flanagan?
Thank you, Mr. Chair. So we're now voting on the amendment. If the amendment.
No, the amendment passed.
Okay, yeah, so we're voting to.
The bill with the amendment.
As named as the amendment.
That's correct.
If it doesn't get the majority, then can another motion be made?
That's correct.
Okay, thank you.
Representative Geisen?
Thank you, Mr. Chair. I still have strong reservations about voting on something with an unknown fiscal note, and I would like the body to just consider that.
Thank you for your comment. Are there any other comments or questions? Representative Granger?
Thank you, Mr. Chair. I think that if we're going to have any rules for public sector, they must not be in rules. They should be in statute, and we should be determining them on a line item instead of just deferring to something as good as some sort of federal authority. If it's important enough that we need to adopt a rule for it or a law for it, it should be in statute, and we should define it that way. Thank you.
Okay, thank you for your comment. Representative Sullivan?
Thank you, Mr. Chairman. I think it's important to note, as Representative Avalani indicated during our earlier discussion, that at present, electrical hazards are not okay under the Department of Labor. If electrical hazards cause an injury, or if they're identified by inspectors, they will be called out, and they'll be called out under the General Duties Clause. It is not fair to employers, it's not fair to employees to have safety standards that are unwritten. So basically, this bill, as amended, will fill a very glaring gap in the New Hampshire Department of Labor safety standards. And it's not that we don't have any concerns about electrical safety. We do. This will simply make it clear what electrical safety is all about in the public sector in New Hampshire. And I don't believe the cost is going to be extraordinary because, frankly, employers, workplaces are expected to be safe today. And for the most part, they are. So I don't think there's going to be rampant spending of any sort to make sure that electrical hazards don't exist. They shouldn't exist now. They won't exist under this new set of safety standards. So I would encourage passage of this ought to pass as amended motion.
Okay, thank you. Representative Flanagan?
Just quickly, and I mentioned it earlier, I don't like the term as effective. When it says as effective, basically as OSHA, that is OSHA. So I'm just really concerned about that.
Okay, thank you. Representative Cahill?
Thank you, Mr. Chair. As we've seen in the, with the data that was provided to us, electrical hazards are existing and injuries do result. There may be even be more than were reported, but we do see that they have occurred. And I don't know what the long-term repercussions were, if there were any fatalities. But I think the cheapest way to, the cheapest accident is the one that doesn't happen. And by having the rules, consistent with OSHA or equivalent to OSHA, and having them known, we could prevent future injuries, future claims on workers' comp, or perhaps future lawsuits that will really hurt your town should something happen that was found to be the town was neglectful. So I'm going to be voting for it. Thank you.
Okay, thank you. Representative Schultz?
Thank you, Mr. Chair. I just want to be brief. It coincides with something I said before we restarted this conversation. Really, in the end, what you really are making a decision about are the 62 people who have had an injury in the public sector in the last 11 years. Those folks are as likely to be Libertarian, Republican, Independent, Democratic. I happen to know a person who had a serious injury, and actually I know two. One was a traumatic brain injury that should have been prevented, and the other was someone who died. Both were municipal workers, and in both cases, there was negligence on the part of that municipality. I think so in the end, you should be focused on how can we stop these injuries and how can we protect workers when we're penny wise and pound foolish that causes permanent injury or death. That's what we're talking about. 62 human beings in 11 years.
Thank you. Is there any other burning thing that we haven't discussed?
Real quick.
Please.
Thank you. I would respectfully disagree with my colleague relative to incorporating this into the statute. And let me say that the Department of Labor under the statute has the authority to promulgate rules now, as do a number of different departments. There is a process for promulgating of rules. The legislature saw fit to set up the jail car process. So rules are promulgated, public input is taken, and it goes to Jelcar. And as I understand Jelcar, they can't change anything. They can just up or down the vote. So if that fails at Jelcar, it goes back to the agency.
Right.
But the idea of incorporating all of this into statute would just bog the system down, which is the reason that this process, as I understand it, is in place. Give them the authority, promulgate the rules, have the legislative oversight through Jelcar. Thank you, Mr. Chairman.
Thank you, I appreciate that. Representative Sullivan, do we have a motion on this? Can you make a motion? Okay, all right. Oh, that's right, we did. All right. We're ready to vote. Mr. Clerk, go ahead.
Representative Avalani,
No.
Representative Seaworth,
No.
Representative Flanagan,
No.
Representative Prout, Representative Warden,
No.
Representative Drago,
No.
Representative Granger,
Nay.
Representative Hall, Representative Labrie Clerk, no. Representative Giason,
No.
Representative Sullivan,
Yes.
Representative Cahill,
Yes.
Representative Ryan,
Yes.
Representative Susie,
Yes.
Representative McKenzie,
Yes?
Representative Schultz,
For the 62 injured, yes.
Representative Leclerc,
Yes.
Representative Staub,
Yes.
Representative Butler,
Aye.
and Representative Creighton.
No.
9-9.
So it's 9-9. Is there a subsequent motion? Representative Drago,
Yeah, I'd like to move interim study.
is there a second?
That would be me, sir.
Representative Flanagan, is there any discussion to interim study? Representative,
Point
yes.
of order, Mr. Chair. It is my understanding that if there's a tie vote on a bill, like on a motion about a bill, that in fact it would go to the floor
It-
with
it's-
no recommendation.
Oh, but there is an option for, I mean, I can ask for another motion to be made. Yep,
I didn't believe that was the case, but I trust you.
thank you, ma'am. Representative Drago makes a motion for interim study, seconded by Representative Flanagan. Is there any discussion to interim study motion?
I'll say something. I do think this is important. The data that we have, numbers don't lie. I think the person who put the data together, the data does show that it was also taken into account per capita. So even though if there's more people that work in the private sector than the public, that was part of the data. The data shows 7 out of the past 10 years, there was more injuries in the private sector that's already governed by OSHA. So not necessarily adopting OSHA in the public sector is going to be any more beneficial. We don't know. But we also heard testimony that the private sector is generally lacking in their filling out the paperwork. So that number for the private sector injuries actually could be higher than what it is now. We don't know that either. On top of that, we don't have the fiscal note. So I don't feel comfortable voting on something that I don't know if it's going to be more effective than what we already have. And we also don't know the cost. So therefore, I'm supporting the interim study.
Are there any other comments? Okay, I do have one thing to say on the interim study. I would like to get this bill passed, personally. And there are several, I think, valid questions, interim study, the cost of the bill, and the definition of exactly what we want them to do. And I'm willing to work on that with my side, to get this through. A lot of work has already been done over the summer, and, we continue to work. Mr. Clerk, recall the Representative Sullivan.
Thank you. I've been at this for a while. I guess it's going to be a while longer. But I am going to vote in favor of interim study because I know where this will go if it doesn't go there. So I will vote in favor of an interim study and continue to work with anyone who's interested in public sector worker safety to take a step forward. Thank you.
Thank you, sir. Mr. Clerk, is there any more comments? Representative Avalani, please.
Thank you, Mr. Chairman. Having worked with Representative Sullivan as well, I think interim study is a good move, so we can continue working on this and possibly come up with something for next year. Thank you.
Okay, thank you. Mr. Clerk?
Representative Avalani,
Yes.
Representative Seaworth,
Yes.
Representative Flanagan, Representative Prout, Representative Warden,
Yes.
Representative Drago,
Yes.
Representative Granger,
Aye.
Representative Hall, Labrie Clerk, yes. Representative Giason,
Yes.
Representative Sullivan,
Yes.
Representative Cahill,
No.
Representative Ryan,
Yes.
Representative Susie,
Yes.
Representative McKenzie, Representative Schultz,
Yes.
Representative Leclerc,
Yes.
Representative Staub,
Yes.
Representative Butler,
Aye.
17-1.
Okay, the motion interim study passes 17-1. This concludes the,
If I would, can I ask if this can go on consent with that vote?
is there,
Anywhere.
interim study,
I thought interim study
we're not
needed
going to
a floor
vote interim study on the,
It doesn't?
in the House.
We'll see it in 6 months.
Okay. It's still here, right. It's not going to the House until we do it. So we'll put it on the calendar in the spring.
Mr. Chair, I have a point of order that's belated.
Okay,
When one of the reps was questioning ranking Democrat Sullivan, I don't know if I'm allowed to name the
that's,
Representative Granger gave characterizations that I believe are crossed the line as a legislator, speaking about the intelligence of workers who very well could be one of us. I believe he crossed the line of decorum as a representative. I don't believe you're allowed to wholeheartedly call a whole group of workers stupid or low IQ.
okay, sir.
Thank you, Mr. Chair. I actually referred to electricians as smart. I said that electricians are very smart. You are allowed to call electricians smart in the committee. Thank you.
And
Okay.
he,
You're-
Mr. Chair,
Okay,
and he
You-
said that the other types of workers were low IQ.
okay. Your objections noted. Thank you. Anything else? Okay, this concludes the executive session on 303. And we will meet again once we get all our bills. I have no idea how many bills we're going to get. So there are in the range of 1,200 submitted. And so it could be a busy spring. Well, we'll see. Okay, thank you, gentlemen and ladies. Motion to adjourn is accepted. Second, all in favor? Aye.